Okay, I think we're mostly everybody in. So, first of all, welcome to today's webinar. We had a huge response to the webinar. So, thank you, Katie, for being with us today. It's I suppose in this environment, there's so much changing all the time, and sometimes it's difficult for both employers and HR people to kind of keep up to date with all the different legislation. So I am delighted to have Katie Ridge with me today, Head of Employer Relations at Adare Human Resource Management. Myself and Katie have done a couple of these webinars before, so I am really happy to have you here today, Katie. You're a pro on this.
Thank you.
Sometimes I forget that you're that I'm supposed to be actually leading the webinar because I just get lost in what you're saying. So I'm have to remember we have a job today. I suppose just to give a recap on what today's webinar will be going over. Katie will be going over, I suppose, the employment legislation changes and what we foresee over the next 12 months. Because there's a lot going on in today's presentation, there will be a question and answer section that's open. I don't think we'll be able to get to all the Q&A, but what I suggest is to don't put an anonymous question in. Your name will be on it. Nobody else will be able to see it. It'll just be ourselves, and Katie and the Adare team can take those questions away afterwards and get back to everybody to go through them with you. When I was speaking to Katie earlier, I suppose there is, Katie, I think you've tried to make it quite practical for people to understand, perhaps, for example, on the pay transparency side, to see where you fit in that. Are you a 50-man company? Are you in a larger man company? And to be able to kind of, first of all, kind of ascertain is where you are actually in that scale. And then again, kind of see where you are prepared, how you are prepared for it. And then contact Katie and everybody. I am seeing that people aren't able to hear me. Katie, can you hear me okay?
I can hear you fine. Yes.
Okay, I think hopefully that's okay. So without further ado, Katie, I'll be sent it over to you. And again, if there's any questions, put them in the Q&A. It is private, and I will share the questions and answers afterwards to Katie and the Adare team. Okay.
Thank you very much, Crystal, for your welcome and a very good morning to a very large group of people who've joined this webinar. We've titled it Irish Employment Law Outlook, What's Ahead for 2026. And those of you who are HR practitioners will know that there is a lot on the horizon in terms of compliance related activities for Irish employer organisations. My name is Katie Ridge, and I am head of employer relations here at Adare. And that's probably my confirmation photograph. So we'll skip on. But our agenda is really going to focus on some of the legislative developments that I've flagged on this particular slide. So just to set the tone and the context, as it were, and this really gives an indication as to the, I think, fairly paced developments that we've had at the very tail end of 2025. And I will touch on one or two of those because very busy time, December for businesses and particularly HR for all that end of quarter and end of year reasons. So sometimes things that happen late in December may not have been flagged adequately. But if we have a look there and we see in terms of what's busy for organisations and HR at the moment, well, one of the things that landed on the 1st of January is the national minimum wage increase. And that now sits at €14.15 per hour. And we'll delve a little into that momentarily. We also know, and particularly people in HR will know, about the commencement of auto enrollment. And obviously, there are key compliance issues there for organisations. What may or may not have been seen and really didn't get as much of highlighting is the introduction of the minimum pension contribution regulations. So they have also commenced, and I think they got a little bit lost in the sort of granular detail of the headliner, which was pension auto enrollment. So we will be dipping into that in this morning's webinar. Um, we've just left January, and that was an important month in terms of the revenue had arranged and announced in September 2025 that um, somewhat associated with the Karsh and Domino Pizzas case, which those of you who are practitioners will know was around the issue of contract of and contract for services that revenue are trying to be even clearer in relation to the boundaries that attach to your classification as a worker. So they allowed for a non-penalty settlement arrangement to facilitate workers and organizations where somebody's employment status may have been misclassified. So I think we will be seeing more resources going into the classification of workers, certainly from a revenue perspective. And as I say, that opportunity just closed there in the end of January. Um, Big one on everybody's agenda at the moment, the mooted date is the 7th of June 2026. And this, of course, is when the Pay Transparency Directive domestic obligations are due to commence. And another one on the horizon is later in the year, and that is the platform workers. Directive, which is due to be transposed into Irish legislation in early December. I've just noted at the foot of the slide that we are keeping an eye on the progression of the pay transparency bill. We are also looking to see what's happening with regulations to compel employers to use the online portal in relation to gender pay gap reporting. And not to forget that there's also in play the collective bargaining action plan, which Ireland Inc. submitted to the European Commission at the close of 2025. So we'll be waiting to see what the response is from the Commission in relation to employee representation around that whole collective bargaining narrative. So these are the key items on our agenda for today's session. Minimum wage rate, auto-enrollment, minimum pension contribution regulations, the Platform Workers Directive, gender pay gap reporting as we move into 2026, the EU Transparency Directive, um, and then looking at some contemplated legislation. So, legislation that is in the throes of going through our parliament at the moment. And the key ones are the issues like the introduction of economic disadvantage as an equality ground, and also in terms of leave around stillbirths, etc. And another big one, because the rate of persons who are working in Ireland presently under the employment permit regulations has grown very substantially. I think it's helpful to understand some of the minimum annual salary increases that are arising in relation to those workers. Okay, so the minimum wage increase. As I flagged in the introduction, the minimum wage increase sits at an increase of 65 cent per hour on the 2025 minimum wage, which was 13.50. So we're now talking about persons who are classified as in that minimum wage bracket, being entitled to a wage of 14 euros and 15 cent per hour for the last month effectively. The range of persons who are captured by this, the data would show us that it's just in excess of about 200,000 workers, so it's not an insubstantial number of people. And also in terms of I suppose, the take home of the minimum wage being something that would be palatable and sustainable. The government moved in terms of the ceiling for the 2% universal social charge has been increased by 1,318. So the salary would go up to 28,700 euros. And this is to avoid penalising minimum wage earners. In terms of, I suppose, how this is seen by workers and indeed has to be calculated by businesses, for an employee earning the national minimum wage and working a 39-hour week, this translates to a pay increase of nearly 1,318 euros per annum. The auto enrollment, a lot of the drama and the workload associated with that manifested in late November and indeed early December of 2025. But I think it's helpful if we remind ourselves about the scope of the legislation, also, of course, known as My Future Fund. So, all employees between the age of 23 and 60 years of age who earn at least 20,000 euros and who are not in exempt employment are automatically due to be enrolled into My Future Fund. The data from the Department of Social Protection shows that about 90% of employers with eligible for pension auto enrolment employees have registered since the scheme went live on the 1st of December. And we know that the kind of clunkily named National Automatic Enrolment Retirement Savings Authority, that's never going to trip off anybody's tongue, I don't think, but they are the administrating entity in relation to the Future Fund scheme. And it's important to remember that this scheme is being gradually phased in over a decade, with both employer and employee contributions starting at 1.5% and increasing every 3 years by 1.5% until they eventually reach 6% by year 10. And also that the state will top up contributions by €1 for every €3 saved by the employee. I thought it was prescient to note that, businesses with a younger and more transient employee demographic are probably the most likely to feel the impact of both the minimum wage increase and the auto enrolment costs in terms of these concurring legislative developments. The other one that's contingent on the introduction of auto enrolment is the regulations, namely Statutory Instrument 637, which really deals with the auto enrolment side, and 668 of 2025. 668 is of interest to us because that is the one that prescribes in relation to the minimum pension contribution regulations. So, in essence, this has introduced a 3.5% minimum total contribution where employers seek to rely on their own pension scheme and, in essence, to be exempt from auto enrolment. So that is the preference in some places of work. And if that is a preference that that place of work wants to implement, that has to be aligned with this 3.5% minimum total contribution. But it also has to come with the express employee consent in relation to their agreement to be enrolled in workplace pension schemes. And the regulations also prohibit a lower contribution rate for temporary or indeed probationary employees. So, in essence, the terms upon which an employer can rely on their own pension scheme are now regulated by the state. And if the existing pension scheme or the PRSA, because that always was another option, if they don't meet the new contribution standards, both the employer and the member, the employee, will be required to contribute to the auto enrolment system separately and in addition to the continuing existing contributions being made to the business's pension scheme. So I think that is something that has been missed in the highlights or the focus of auto enrolment. That if you want to sustain your own pension scheme or the PRSA, there are now these very strong parameters that attach to that. So it is an option, but you're constrained in relation to addressing the parameters of the regulations. And also, the other one that's important there is to get the consent of the employee in relation to them joining the, if I can call it, the company pension scheme. So, the Platform Workers Directive, that's something that is coming down the track, albeit later in the year. But it takes a while to, I suppose, get organised within employer organisations to be ready to engage around these directives. So I'm going to flag some of the key contents of the Workers' Directive. So in the first instance, the objective is to improve the working conditions and protect the personal data of platform workers. And I suppose then that would drive us over to the right hand side of the slide there, and it would provoke what is a platform work, and this is work that is organized through a digital platform based on a contract between the platform and or an intermediary and the individual, irrespective of whether there is a contract between the individual intermediary and indeed the recipient of the service. And the platform worker is someone who provides their labour through an online service, so maybe typically a website or an app at the request of the recipient. The directive notes that it's not a person who is selling a product, and they give the example of the Airbnb service that I think many of us would be familiar with. The key reforms of this directive are to create a presumption of employment where characteristics of direction and control exist. So, again, these are relatively new types of work arrangements, and this, in essence, is the law keeping up with the nature of these work arrangements and setting the scene in the legal context whereby there will be a presumption of employment and therefore bringing all of the attendant employment protections and rights into that relationship. If the relationship shows the characteristics of the entity issuing directions to the individual and or there being behaviors that could be described as control related. And then the second element of the directive's objective being to establish limitations on the processing of personal data by means of automated monitoring systems and also automated decision-making systems. So the digital labor platform is the person or the business or entity providing the service through electronic means, i.e., your website or app, at the request of a person who receives the service. A digital labor platform is providing work that is organized in return for payment, irrespective of where the work is provided. And a digital labor platform involves the use of automated monitoring or decision making systems. And I reference that because what's important in the impending legislation from the directive is that the burden of proof will sit on the digital labour platform to rebut the presumption that there is an employment relationship in existence. So I think that is going to be significant in terms of where the book stops, as it were, in relation to the nature of the relationship between somebody who is recognized as working in this environment and then being classified as a platform worker. We await the detail, of course, in relation to this directive over the course of the next couple of months. So we'd expect to be seeing something in relation to quarter 2 and 3, I would expect, in relation to some of the domestic bill content. Okay, so the gender pay gap reporting then. Many of you will have been involved directly or at least in gathering the data, potentially, if you are an organisation to whom the scale of reporting applied towards the end of 2025, because we know that the legislation has determined that the new scale is that employers with 50 or more employees have been in scope in relation to the gender pay gap reporting requirements since June of 2025. There is I think, universally held view in relation to both the employer side of the equation and indeed the department side of the equation, that there is a need in relation to regulations around uploading this important data to the government platform. And regulations will be needed in relation to complying with what will be more reporting obligations around gender pay gap reporting in 2027. So we'll await to see the developments on that. I know that there was supposed to be a pilot in relation to the government portal, but I believe that more work was needed in relation to that particular project. We can also say that the reduction in the employee threshold around gender pay gap reporting brings more than 6,000 organisations under the scope of the reporting regime. So again, that is a significant development in relation to discriminatory pay data. And we also are aware that the definition of basic pay has been updated to include payments made during statutory leave, those ones that we would be aware of, such as maternity, paternity, and adoptive leave payments. We know that the reach of the gender pay gap reporting in relation to basic pay now also captures employees paid in other currencies. and it also reaches into share options and interests in shares. So we are really getting in and under the bonnet of discriminatory pay, and a line of sight on that with this part of the pay transparency directive. I think it's interesting to note that the Commission determined that 12% was the estimated gender pay gap estimated across the EU for the most recent reporting period, which would be 2024. So a significant gap on the most recent data that's available. So in terms then of the updates around the gender pay gap reporting, we know that if pay differences cannot be justified by objective and gender neutral criterion, that the organisation must, and this is in close cooperation with worker representatives, remedy these differences in a reasonable time. And back to my point in terms of the collective bargaining end of employee relations, it'll be interesting to see will that lean into the gender pay gap reporting and particularly this issue of pay differences. We also know that joint pay assessments are mandated where there has emerged to be an unjustified pay gap of 5% or more, and it hasn't been remedied within 6 months of the gender pay gap report. And also, again, around transparency, and this will tie in with the pay transparency that we will look at momentarily. The assessments have to be shared with workers and their representatives, and indeed the designated monitoring body. Employee representatives and organisations must together analyse and plan remedial measures for any of the gaps that are identified. And I've touched on many of the changes there in relation to reporting, that it will include benefit in kind when we're looking at a definition of pay, that employees will be grouped into categories of like work or work of equal value, so not just four quartiles, that senior leaders must vouch the accuracy of the figures after they've had a consultation with worker representatives, and the worker reps will have access to the calculation methodology of the gender pay gap. So very much a light being shone in relation to this part of equality legislation. So let's turn our attention now to the topic of the gender, or rather the EU Pay Transparency Directive. I thought it was helpful to maybe start with a timeline. And we see that the adoption of the directive occurred in 2023. And we can see then the indicative timeline for the transposing of this legislation into Irish law. And that essentially is where we get the 7th of June 2026 date. And then we can see further on the horizon provisions in relation to the reporting requirements, and obviously starting with the larger scale organisations. And they're having annual reporting obligations as of June 2027. And then the smaller organisations following suit at a later time. I think it's also important to flag that there has been no progress as we speak in relation to the general scheme of this act that was published in January. And we are awaiting the pay transparency bill to be published. But I also think that it is important, and there has been a bit of commentary on this in the media in the last short while. Will it happen in June 2026? I think that the indicators are that it will, simply because this really essentially is about equality legislation across the member states. And I think that there's also the factor of when a member state misses an implementation date, there is an automatic fining system in relation to that state. Now, the fact that there is maybe 19, 18 weeks left in terms of organizations hitting preparedness for compliance, I think is a significant ask. And we're waiting to see what, if any, resources in the more generic sense are going to be flagged by the government. But I think that regardless of, and while the 7th isn't set in stone because we don't have the legislation yet, I think one would be very well advised to behave in a cautious and compliant manner, and be ready in relation to the different provisions of this directive when it is enacted domestically. So let's have a look inside of the directive. So if we were having an overview, we would say that it's looking in the first instance at greater transparency on pay for job applicants. So any of you who are involved in recruitment and selection would need to be very conversant in relation to the provisions around the recruitment and selection, and how that links in with salary. So that in a high level summary would advise that you have to be able to provide access to information on a starting salary or pay range to putative employees prior to their interview. There is a ban in terms of asking candidates about their previous salary history. And I think that that's a cultural change for many organisations who haven't been aligned with very clear and precise pay scales. Maybe less, hopefully less of a requirement is to be compliant in relation to gender neutral job descriptions and titles. And there's a whole school of data there in terms of the language that are used in advertisements, that there would be supporting data to say that certain terms would attract more female candidates and certain terminology would tend to lean into more male attributes. So while we've always had to be a non-discriminatory under equality legislation around access to employment, I think the bar is going to be raised consequently. Information on pay and pay progression. So workers will have access to pay setting criterion, the right to request information on pay and average pay progression levels. They will have an entitlement under the enacting legislation to be given by their employer an annual reminder of this right to request information about their pay and pay progression. And whereas contractually businesses may have had explicit content in the employment contract that prohibited or restricted workers on disclosing pay information, that prohibition has been heavily impacted in terms of very reduced circumstances are available for businesses in restricting relevant employees from disclosing pay information. I've touched on the joint pay assessments as they arise under the gender pay gap reporting, and then the remedies that are contemplated would include rights to compensation. One we'll talk about in a moment is the shift in the burden of proof, orders to stop infringement, and more typically, various penalties and fines that have yet to be determined in the domestic enacting legislation. So the bill will transpose the EU Pay Transparency Directive, and it will have to align with the objectives of the directive, and that is to seek to improve equality in the workplace by mandating transparency regarding remuneration and addressing gender pay gap discrimination. We know that under the directive, and our transposing legislation will have to reflect this, organisations will be required to include salary ranges in job advertisements without candidates having to ask for it. This, of course, doesn't prevent either party from negotiating outside of the stated pay range. But in addition, employers will not be permitted to ask applicants about their prior salaries. And I've already touched on the requirement. So I think it's gone up a level in terms of you being able to demonstrate that you have advertised in a gender neutral way. You have an additional right under the directive for employees to receive information regarding pay levels and the pay levels of colleagues performing the same or similar work. And employees with over 50 workers will be required to make accessible to employees the criteria that they use to determine workers' pay, their pay levels, and pay progression. And these criteria are required to be objective and gender neutral. So, in essence, we should be seeing that there is a tie in relation to performance, seniority, and indeed skill sets. I've asterisked the over 50 workers because the directive has said that that is the minimum requirement for member states within the objectives of the directive. But it is important to remember that member states are permitted to have a lower threshold than the directive, because always when a state is implementing a directive, they must give at a minimum what's in the directive, but they may give more. So the domestic bill, it's unclear in relation to this part of the directive. Will the bill, in dealing with pay progression, stick with the over 50 threshold in terms of the relevance, or will it not prescribe a particular threshold? So that's one that we will be interested to see how that pans out. The bill will also deal with employees having the right to request and receive information in writing about their individual pay level and the levels for workers in similar roles. Those pay levels must be broken down by gender and apply to workers performing the same work and workers performing work of equal value. And again, a new requirement, if enacted, will be that the information must be provided in writing within 2 months of the request being made. So that enables workers to be proactive in relation to lines of sight and full disclosure information in respect of their remuneration and how it's calculated and progressed. Employers will not be able to restrict employees from discussing amongst themselves or disclosing their pay for the purposes of the enforcement of this principle of equal pay. So um, this is clearly again and again another tool in the arsenal of the Commission in getting creating a space, as it were, in which it is much more comparatively easy for an employee to have access to all the information that would give them the insight in relation to how they're being paid. So while you can still have a non-disclosure requirement for employees for other reasons, uh, for example, you may not disclose your pay to competitors. There is very much a weakening of that maybe cultural prohibition that employers might have relied on in a much more macro sense. A big one is the shift in the burden of proof in relation to pay discrimination cases. So, this is certainly something to concentrate the minds of organisations because disquiet in relation to a potential unequal pay situation may manifest in litigation or at least a complaint to the WRC. And the directive determines that the transforming legislation will move the burden of proof onto the employer organisation. So essentially, that will mean when the bill is enacted that the employer will be required to prove that there has been no direct or indirect discrimination regarding pay. And as we speak, if somebody was bringing a discrimination and equal pay claim, the burden in fact sits on the complainant to present facts, typically uh, numerical data evidence that would suggest their complaint of discrimination has some validity. And then, if the adjudicator is satisfied that there is enough there to suggest discrimination in relation to pay, the matter would progress and the employer would have to set out its defence. But the bill is contemplating that this will change unilaterally, sorry, this will change uniformly, and that there will be a burden on the employer once the legislation is introduced. So that kind of brings us to the like work uh, description. And the indications are that there's not a whole lot of case law in relation to what the pay claim produces in relation to discrimination and where the work is deemed or argued to be of equal value. So, this will be an interesting space in relation to pay discrimination claims. I think it's very clear for people when there is, I'm being paid less than the other person and the work is the same. It's very clear that it's interchangeable. I'm being paid less and the work is similar that the comparator that I've pointed to is doing. Again, insignificant maybe differences. But work of equal value is where entirely different jobs can be compared. So you've somebody who's running maybe a large work-based canteen in a big organization, and you've somebody who's running the warehouse in that organization. There's the potential there for a claim of unequal pay, or I'm being discriminated against, and I'm predicating my claim on a claim of I do work of equal value. So that would be looking at equivalence in me, the complainant, and the person who I say is a comparator around issues such as skill, physical and mental requirements of the job, responsibility, and working conditions. And what I think is very pertinent is that the Pay Transparency Directive references when talking about work of equal value, precisely those characteristics: skill, effort, responsibility, and working conditions. So there's a lot going on, and there will be a lot going on in relation to organizations being fit for purpose around the pay transparency legislation. So, how can I get ready is a question that we are often asked in Adare. And some of the steps in relation to that readiness will include having a review and audit of your pay structures, updating your recruitment practices, enhancing your internal processes, and looking at how your organization is faring when it comes to gender pay gap reporting. So, challenges in relation to the right to equal pay for equal work are certainly on the horizon, if only because the work of equal value concept is not as well traversed in terms of the case law. And this will be a new space in relation to these kind of equal pay claims. And we expect there will be quite a lot of activity in this arena. The organisational risks would be possibility of legal proceedings. So, in terms of individuals bringing claims that they've been penalised, claims in relation to the payment of wages legislation, or possibly constructive dismissal. Um, the sanctions that are to be available in member states, the directive says, should set effective, proportionate, and dissuasive sanctions. So we will expect that the implementing legislation will have to reflect that high threshold. And so we would expect that fines and penalties would be significant in relation to being persuasive of organisations not to engage in discriminatory pay activities. Clearly, there's also the reputational damage, given that for a number of years now, other than in exceptional circumstances, employer organisations are identified by name when there is litigation in the WRC. So, court proceedings can produce compensation for employees. And while there isn't a history of class actions in this jurisdiction, um, it may be something that would be looked at if the state felt that that is something that would be assistive in relation to moving the dial in relation to pay transparency. So, just to conduct a very brief poll here in relation to how you're going to get into a place of compliance when it comes to your pay transparency pathway. If you ask yourself the following three questions: if an employee formally requested their pay level and the average pay for comparable roles tomorrow, could you deliver an accurate, legally compliant response on time and with confidence? Could you defend a complaint in the WRC when the burden of proof has shifted to your organisation to justify pay differences that aren't objectively justifiable or explainable? And really, all of that feeds into how ready are you and your organisation for pay transparency? If, as I expect many of you are ticking the no box, then I would suggest that you talk to us in Adare today or in the near future about helping you in your readiness for pay transparency. And we can do so in the context of pay transparency readiness assessment and indeed any necessary workshops that you would determine are appropriate. So hopefully that is something that will be helpful to people in relation to this journey that we're all going to be on around pay transparency compliance. Now, looking into the potential legislation that will also feature during the course of 2026. Some of the bills that are on the horizon, the organisation of working time, leave for health screening purposes bill. So this is a bill that will, it's at the second stage of the legislative process at the moment. And when this is enacted, it will entitle an employee to 3 days leave with pay per year in order to avail of a cervical, breast, or colon cancer screening program provided by the HSE for the benefit of such persons' age, gender, and general health status, or any other screening program recommended to the employee by their medical practitioner for the same purposes. This bill addresses issues such as confidentiality and provides protections against penalisation or unfair dismissal if employees avail of the leave. And when enacted, it's expected that the Workplace Relations Commission can award compensation of up to 2 weeks' remuneration for breach of the legislation or direct, indeed, the granting of the leave. One that I think might have missed some people because it was enacted in mid-December 2025 is the Employment Contractual Retirement Ages Act. And this is important given the recent phenomenon of persons who've reached contractual retirement age seeking to extend their working life. So, the main features of this act are that where an employee is subject to a contractual retirement age that is below the state pension age, which is currently 66 years of age, and many indeed private sector employers have an historic retirement age of 65 years. So, this would be something that would be, I think, applicable to many employers up and down the country. So if there's a 65 years of age contractual retirement clause, the person impacted by that may provide their employer with written notification that they don't consent to retire at that contractual retirement age. And if the employer still wishes to proceed with enforcing that contractual age, they cannot do so prior to engaging in a written reasoned reply with the applicant employee. And they have to establish that the contractual retirement age is objectively and reasonably justified by a reasonable and legitimate aim, and that the means of achieving that aim are appropriate and necessary. Employees will have the right to refer complaints and seek redress through the WRC. Now, it's important, obviously, to separate out that there is no impact on retirement ages that are set out in law. And we know that, for example, people who went into the public service and maybe in the last couple of years, their retirement age could be that of 70 years of age. But for many people who are existing employees, certainly in the public sector, of course, that's going to bring in, in the private sector and indeed not for profit sector, I think many of those persons will fall into the catchment of this particular piece of legislation. Another important bill, it's currently at its fourth stage, is the Pregnancy Loss Miscellaneous Provisions Bill. Again, this is proposing to provide for a period of paid leave on the loss of a pregnancy. This will require amendments to the Organisation of Working Time Act, and in its current draft, the entitlement would be available to employees from day one of their employment and be for a period of 5 working days. And there's a requirement for the pregnancy loss to be certified by a registered medical practitioner. There is also contemplated a 2.5 working days entitlement for the other parent of the pregnancy loss. And it goes without saying that the protections that subsist in relation to the Unfair Dismissals Act would be maintained in relation to this proposed legislation. The Equality Miscellaneous Provisions Bill is another interesting bill that is aimed at prohibiting discrimination, and this time the characteristic is a person's socio-economic background. So this would, if enacted, require amendments to both the Employment Equality Act and indeed the Equal Status Act. The bill is looking at including socio-economic disadvantage as a discriminatory ground and to provide the necessary changes as to how comparators would be used if somebody maintained that this was the form of discrimination that they were enduring. It also proposes amendments to the Act which would allow an employer to provide for certain benefits or affirmative or positive action in relation to the socioeconomic disadvantage category. This is at an early stage presently, and that is at stage 2 of the legislative process. It's something that's been talked about for a while, so it's interesting to see that it is on the proposed legislation for this year for the Dáil. And another piece of relevant legislation is the introduction of, or the proposed introduction rather, of the Employers' Insolvency Amendment Bill. And this is in essence addressing the insolvency payment scheme in relation to employees being able to access the social insurance fund even when their employer stops trading without formally entering into liquidation or other associated administrative or receivership uh, classifications. So this bill has completed its third stage, but obviously would be a significant addition in relation to access to benefits for people who are impacted where there is an insolvent business and they obviously have no work available to them as a consequence. Finally, the employment permits minimum annual remuneration thresholds. So, as I touched on, the number of persons operating under the permit system, which essentially is a system that allows non-EEA European Economic Area citizens to work in Ireland where they hold the correct employment permit and meet the corresponding salary threshold. So many businesses are leaning into this as a necessity in terms of being able to access the relevant skill sets that their businesses need. The minimum annual remuneration is the lowest salary that must be paid to a non-EEA worker for an employment permit to be issued to them or indeed renewed. So the thresholds that are applicable as of the 1st of March this year, the critical skills employment permit